Good morning and welcome to the 9th episode of Coffee with Casey. I'm Casey Hicks, a shareholder and the office managing attorney here in Chicago. It's bright and sunny here in Chicago today, finally. Hopefully it stays that way for a few days. This morning, I'm enjoying a nice cup of Starry Eyes coffee from Dark Matter, one of my favorite coffee shops here in Chicago. While I go over some quick housekeeping items, why don't all of you out there put your drink of choice in the chat? Coffee, tea, maybe something else. As a reminder, this is an interactive session. We appreciate receiving questions live as we're going through today's information. You can type any questions that you have using the question button in the control panel. I'm looking forward to have an interactive and exciting session this morning. I should have some more coffee. And I'm happy to welcome back Laura Alms. She is a second-time guest. She joined us on episode 4, and you can go on Weltman's website and view that episode where we talked about probate matters if you would like. And as a reminder, all of our past webinars are on our website and available to be watched. With that, I'll kick it over to Laura. Welcome, Laura.
Hi, Casey. Happy to be back. Am I the first repeat guest?
Yes.
That's very exciting. I feel like a Saturday Night Live host. So just a little bit about me. I'm from a small town in Illinois, west of Chicago, about an hour west, out near DeKalb. It's called Maple Park. I attended the University of Illinois for undergrad and then Northern Illinois University for law school. So I am an Illini and a Husky. I'm in my 12th year of practicing law. This is my 6th year with Weltman. And my focus here is on consumer collections. So handle a wide variety of matters, but lots of credit card matters, lots of student loan matters. Those make up probably the majority of the cases that I handle. And when I'm not practicing law, a lot of my outside interests involve being on the water, especially kayaking in the last few years. I've gotten to really enjoy whenever we go traveling, we try to go kayaking someplace. And I also enjoy crafting.
Oh yes, crafting. You've done some great projects here for the office.
Yeah.
For a reminder, everyone out there today, the webinar is being recorded. At the conclusion of today's session, a link will be sent with the recording to all of the attendees. There'll also be a short survey sent to you at the conclusion of today's webinar. Feel free to share any feedback that you have, positive or negative, or if you have any topics that you'd like to hear us talk about in a future episode, we'd love to hear those as well. While we jump into our key topics for today's webinar, I know we have a big game coming up on Sunday, and some of us here are football fans, some of us here are Taylor Swift fans, so I thought it would be nice for people to put either their favorite Taylor Swift song or who you're rooting for on Sunday, if you're rooting for the Chiefs or the 49ers, and we'll do a survey at the end of the webinar regarding those results as well. My favorite Taylor Swift song is Out of the Woods off of 1989, Taylor's version, of course. And with that, we'll jump into today's topics. We will be focusing a lot on Illinois today. So if you do have questions that are outside of Illinois, that maybe you have an account in a different state, feel free to reach out to us afterwards and we'll either try our best to answer it or point you in the right direction to another contact here at Weltman. So today we're going to be talking about if you receive notification of a potential fraud when you have a credit card or a debt buyer account that's in active litigation, what do you do next? We'll also talk about the requirements of Illinois Supreme Court Rule 280.5, which is basically related to allegations of identity theft or fraud and what is required to be done by the consumer and what's required to be done by the creditor. And specifically, we'll talk more about the affidavits that are required during Illinois litigation. With that, we'll jump right into our first topic, which is notification of fraud in Illinois. Now what? So Laura, why don't you kick us off?
Thanks, Casey. Most collection matters that reach the litigation stage don't have issues arising from identity theft. And the reason is pretty simple. I know a lot of our participants in the webinar are employees of financial institutions. And as you know, there's a lot of oversight, regulation, companies have policies and practices in place to deal with fraud and identity theft. And oftentimes a company is the one that's even flagging the theft before a consumer even knows that it's occurred. So usually files are very well vetted before they get to the litigation stage. The biggest exception to this occurs with credit cards. And again, the reason is pretty simple for this. They're a widely used product. Tons of people have credit cards, even if they don't have other types of accounts and they don't use other types of financial products. Consumers are much less sophisticated than a financial institution. And a lot of times ID theft might occur in the context of familial relationships. So it might be something that maybe they aren't that willing to report or discuss with the financial institution until it gets to the point of litigation. And these people are most vulnerable to bad actors, so that's where fraud can usually occur. If you get notified by your attorney, or even if the consumer contacts you directly when a file is in litigation and flags identity theft with the account, the first thing that you should do is start your investigation early. Illinois law does allow a creditor a certain amount of time, which we'll get into later, to respond to identity theft allegations, but isn't something that you should sit on. Start your investigation early and start with a broad search, and then narrow it down as you get more information about the potential fraud. Make sure that you're consulting with your counsel. They're going to have a lot of ideas for things that we can ask the consumer for, different types of proof like police reports, things along those lines that they may have filed contemporaneously with the fraud, may not have filed at all, might be willing to file now. You can ask the consumer if they're willing to pursue a criminal case. Again, a lot of these involve familial relationships. So sometimes, they're not really willing to take that step, but now that it's gotten to the point of litigation, they might be willing to contact the police and cooperate. And then the last thing is to ask the consumer to complete all the necessary affidavits under Illinois Supreme Court Rule 280.5. And then just a little bit of advice, because I know those of us in the industry might tend to maybe get a little defensive or, think that, no, this data is valid. Just try to keep an open mind and listen to what the consumer has to say. Listen to the details and the facts that they're willing to provide, and let that guide your investigation. So federal law, as again, many participants work for banks, credit unions, financial institutions, you're very familiar with oversight and requirements of various federal state laws. Those typically aren't going to be enough in Illinois to overcome the Illinois rules requiring you to file additional affidavits. So you may have fulfilled all of your requirements under federal law. There's a few other steps in Illinois you need to take to fulfill Supreme Court Rule 280.5. So Illinois Supreme Court Rule 280 is a rule that was enacted in 2018, and it has a few different subparts, including the part that we'll be focusing on today, which is 280.5, which deals with fraud and identity theft. The purpose of the broader rule when it was enacted was to provide clarity to defendants regarding the entity that was bringing suit, how the damages were calculated. It standardized the pleadings because it requires creditors for credit cards and debt buyers to use an affidavit when bringing their claim. And the affidavit is supposed to be adopted in appearance and in substance. So anytime you see a credit card collection action being filed, the affidavit will look the same no matter who the credit card is. And that provides consistency for the consumer.
Sorry, Laura, I just jumped ahead a few slides there, but we did have a couple questions come in. So since this rule was enacted in 2018, in your experience, have you seen more or less allegations of fraud dealing with credit cards or debt buyer accounts since this rule was enacted?
I would say that we probably see more come in when consumers are represented like by counsel or by like free legal aid services. Here in Cook County, there's a program that's been enacted called the Early Resolution Program that puts consumers in contact with free legal aid. And so once those consumers are hooked up with those attorneys, then they're able to bring their claims more easily than they would if they were representing themselves. So I'm not sure that there's been more or less of an increase in volume per se, but I think the use of the affidavits and the increase in legal aid services has definitely led to a more standardization when those claims are brought.
Yeah. And then the other question was, are you seeing more affidavits being filed with the cooperation of counsel or by pro se litigants, which you kind of just addressed? Because we do have the ERP program here in Cook County that was developed during the pandemic, and there's also other, volunteer legal services throughout the state, Land of Lincoln, and a few others. And we do see those organizations involved in these types of cases and completion of the affidavits and things like that. So I think we did answer that question. So any other questions, feel free to put them right into the chat for us.
So now focusing on the last section of 280, section 280.5, it provides a clear method for defendants to assert identity theft. So kind of leading into that question about like pro se litigants, it provides a really easy way for counsel. If we're talking to a consumer and they raise the issue of identity theft, it's a very clear path that we can point them to, that there's this rule in place and these are the affidavits that are provided. Here are the forms, and then they can take that on themselves. So Rule 280 applies to only certain groups of creditors. A complaint is subject to Rule 280 if it originates in a credit card debt or if it's brought by a debt buyer. And we've provided the definitions here on the slide. Credit card is pretty straightforward. I think we're all familiar with what a credit card is. Debt buyer would be an entity or a person that purchases a debt after it's delinquent or charged off. And that's the key section there. The debt has to be delinquent or charged off at the time it's purchased. Just because an entity purchases a debt, if it's in good standing, then they don't qualify as a debt buyer. And then narrowing it down to the specific part of the Rule 280 to 80.5 that deals with identity theft. The affidavit requirements are twofold. Once a defendant has asserted identity theft, they have to complete two different affidavits. One is an identity theft affidavit and a form approved by the Illinois Attorney General. The second is an identity theft affidavit made by the Illinois Supreme Court. The Attorney General affidavit is not filed in the case, but the Supreme Court affidavit is. Both affidavits are required to be sent to the creditor. Once those affidavits are served on the creditor then has 90 days to either decide to dismiss the case or to file a counter affidavit that outlines why they believe the debt is valid.
And we do have two samples that we've provided in the slides of both of these affidavits and the differences between the two. But Laura, could you tell us like the difference between the one that's filed with the court and then the one that's sent to the Attorney General and the different types of information that is required to be included?
Yeah, this first identity theft affidavit that you see on the screen is the Supreme Court affidavit, and that's the one that's required to be filed with the court. This one is very simple. It's just the defendant's name, that the lawsuit is brought on a particular debt, they don't believe it to be valid, and that they've also filed the Illinois Attorney General affidavit. So the language is really simple. There are minimal factual allegations, if any. It's easy for the consumer to complete, but it doesn't really provide a lot of information for the creditor. It doesn't really give you anything to go on in terms of your investigation. And there's a link to the affidavit at the bottom if anybody wants to look it up. It is a form affidavit, so you can find it and anyone can use it. The second hurdle is a little bit more in depth. The Attorney General affidavit requires more information of the consumer and requires specific facts to be asserted as to what's being alleged. So this is what's really going to provide the creditor with a framework for your investigation. We talked about starting early with a broad investigation. This is going to allow you to narrow in to the consumer's specific allegations. And it also tends to dissuade consumers that, maybe they are a little bit less than truthful, or maybe they know how the charges got there and they might dispute them, but maybe it doesn't necessarily qualify as fraud. Taking the step to actually make a sworn statement tends to dissuade people from taking that step.
Laura, does Supreme Court Rule 280.5 require a police report to be filed in conjunction with these two affidavits?
It does mention the police report in the form affidavit, which we have on the screen here. It's not a requirement. It asks if one has been filed, and it asks if the consumer is willing to participate in a police investigation and willing to release the information to the authorities. So that kind of ties into what we talked about before. A lot of these are familial relationships where maybe they weren't willing to take that step previously and maybe they didn't file a report contemporaneously, but now that they're being faced with litigation, that might be something that they're willing to do, and filling out the affidavit might encourage them to do so.
Mm-hmm. And as you can see on the screen, the Illinois Attorney General affidavit does require a substantial amount of more information about the alleged fraud than the one required to be filed with the court. There's a lot more detail here to be filled out.
So now that the defendant has served both affidavits on the creditor, the next step is for the creditor to complete their investigation and file a counter affidavit. Failure to file a counter affidavit risks dismissal with prejudice by the court. So the court on its own motion can dismiss the case if no counter affidavit has been filed.
And we did have a question come in about this, Laura. What happens to the status of the lawsuit that's pending while the creditor has this 90 days to investigate the potential fraud?
Normally what we would do in litigation, we typically have like several status dates. When we have a status date, we would just indicate to the judge that these affidavits have been received by the creditor. We tell the judge our deadline that we need to file a counter affidavit, and then we'd set a follow-up status date after that. So we normally aren't going to court in that time. We're just waiting on the creditor to complete their investigation, and we're working with our clients with questions and concerns that they may have throughout the course of their investigation and working with them to develop their counter affidavit. So when we are working with clients to develop their counter affidavit, we'll usually provide you with a framework of an affidavit, and the kind of meat and potatoes of the affidavit is going to be your investigation. So we'll work with our clients to plug in all the specific facts that they may uncover as their investigation is underway. As mentioned previously, you want to start broad and then narrow it down depending on what the consumer provides in the Attorney General affidavit. Sometimes it's very illuminating. The consumer may have very specific things, a very specific person that they can point to that committed this fraud. And once you review the facts of those affidavits, it really may line up with the documents that you have in your file, which also ties into keeping an open mind. When you do your investigation, you just want to draw on all the resources that you have available to determine if the allegations actually have merit. So those might be recordings of phone calls, account notes, call notes, transaction entries, noticeable changes in information or patterns of behavior, where transactions tend to like really swing from one pattern to another. Uh, and part of that also is your frontline employees that can really provide key information, um, especially like I said, I'm from a small town. Um, people at the bank know everything. So somebody might come in and they might be chatting about, things that are going on in their life. Maybe they've been talking with a certain person online and they're trying to help them out. Things that would key you into the fact that this person might have been defrauded.
Mhm.
So if the allegations do not have merit, we'll work with our clients to develop that counter affidavit. The more detail, the better. The more specifics, the better. Especially if you can provide specific facts that counter the defendant's facts. Use that personally identifiable information that the defendant has provided. For example, the AG's affidavit asks for address history. If the person has lived at one address for the last 35 years, but you see on the account the address has changed several times, that could be like some specific facts that you could use to confirm or to counter the defendant's facts. And any documents that you could provide to a firm like ours that we could either attach to the affidavit or provide to the opposing party, that's always helpful to lend weight to your allegations.
Another question, Laura. So what if the creditor determines that the account is not fraudulent, they file their counter affidavit after they completed their investigation? What are then the next steps within the litigation to move the lawsuit forward?
So if it's a small claim, there's no discovery required. So we would normally just set the case for trial then. And you should prepare to come in person to trial with all of your support information that you've uncovered during your investigation, and be able to discuss your investigation and how you concluded that the account was valid. If the claim is larger than $10,000, at least in Illinois, small claims are under 10, other claims above 10. You may be required to go through the discovery process, in which case we would want to turn over all the documents that support the finding that the account was valid. And then once the discovery process is complete, then again, we'd set that for trial, and you'd want to be ready to appear and testify as to the validity of the account. What if the defendant is right? Don't panic. We've had some clients that have conducted investigations and determined that what the defendant was saying was true and that they did not want to pursue that debt any further. The court's not going to penalize a creditor for dismissing the case. You had a good faith basis when you filed the case that the debt was valid. You were provided new information during the litigation. You did your due diligence, and then you're doing the right thing by voluntarily dismissing. So the court isn't going to hold you accountable for what you didn't know at the time of filing. Another important aspect besides voluntarily dismissing is to unwind any negative impacts on the defendant. For example, we've had some of these claims raised post-judgment, where we've already engaged in post-judgment collections, things like bank garnishments and wage garnishments. If that's the case, you're going to want to unwind all those transactions, return any funds to the defendant, and make them whole.
And then we have a few minutes left, Laura, so we can touch base a little bit on these. I know we had 3 scenarios that we wanted to talk about. So I'm just going to skip ahead a little bit to those slides. And for all of you out there viewing, the 30 minutes always seems to go by so fast, but you will get a copy of this deck with the survey after today's webinar. So just a reminder for everyone on that. But I know we wanted to get to these 3 scenarios.
Yeah, and I think the slides that we skipped were just kind of indicating that if you're not a credit card or a debt buyer, if your claim isn't based on credit card, the same kind of steps apply. So any kind of debt, it's really great to point them to the AG affidavit to get those facts. The first scenario that we have as an example is, what if a defendant is asserting fraud or identity theft with respect to only certain transactions. So maybe they're pointing to a few months of credit history and they say, I didn't make those transactions. So what to do depends obviously on the circumstances and what they're alleging, but generally you can rely upon your contract documents that are governing the account. So any account should have terms and conditions. Typically these would outline dispute resolution procedures, and you can ask the defendant, did you raise a dispute at the time of these transactions? If not, why not? Why didn't you assert any errors when you saw these charges originally come through? If they're fraudulent, why weren't they disputed at the time? And that's normally how we would address those in litigation. Second scenario, a defendant is claiming fraud occurred 15 years ago and you don't have the account statements any longer from that time period. As we know, most document retention policies are 7 years, and you may not have account statements from prior to that period. So you would want to look at any evidence that you have that may exist. Again, any call recordings, account notes, anything like that, and then reinforce what's occurred in the time since the fraud was completed. If they're alleging that the fraud occurred in 1997, but they've kept the account open until 2024, why didn't they close it? Why wasn't the dispute timely raised? And again, we go back to policies, dispute resolution procedures that you can rely on. Third scenario is a defendant that claims it can't be proven that they were the one who opened the account. And we do see this a lot in litigation, especially with pro se defendants. And in this case, we'd want to rely on your quality control, quality assurance procedures. What information did you obtain when the account was opened? How did you cross-reference that information to confirm the person's identity? And then use the personally identifying information that they provide to link the defendant to that account. Well, your address matches, your social security matches, all of those different things. And then again, you can refer to account history. Like if it wasn't you, why have you allowed these account statements to come to your home for the last 5 years? Things along that line.
Yeah, exactly. Well, thank you very much, Laura. Thank you for being the first second time repeat guest.
Thank you for having me.
Yes, you provided us with a lot of great information today. For a reminder of everyone out there, we did focus specifically on Illinois today. So if you have a question regarding another state, please feel free to reach out to us. I'm going to put our contact information up for you. Feel free to reach out to me or Laura via phone or email, and our information's right there for you. Thank you again for attending today's episode. Please stay tuned for details on episode 10. And as a reminder, a recording of today's webinar with additional information will be sent out to you shortly. Along with this PowerPoint presentation, I know we did have to skip over a few slides, unfortunately. Please take this survey as well. We appreciate hearing your feedback, and if you have any future topics you would like to hear us discuss. Thank you again for attending today, and have a great rest of your day, and go Chiefs. Bye.
Thanks, Casey.